Jai Hind everyone, my name is Vishal Gupta and I am from Ajay Kumar Garg Engineering College. Today we are going to discuss topic named copyright. Actually it is part of one of the subject of Abdul Kalam Technical University, that is Constitution of India Law and Engineering, which is taught in third year. So firstly let's start to understand what copyright is. So copyright, it is a monopoly right restraining others from exercising that right which has been conferred on the owner of the copyright. So firstly here what we are getting to see that it is a kind of monopoly right, and I think some of you must have read a subject that is economics, in which we generally talk about this monopoly. So in monopoly what happens that there is a single seller, there is a single producer, manufacturer, seller or distributor, and that person is having sole right to distribute, to manufacture that particular commodity. But here what we are getting to see, here we are talking about these copyright, and copyrights generally what they are, these are intangible things. So if there is intangible thing, then what will happen, we will get to see that we need to analyze such things, that how we should basically offer rights to people who are having such intangible things. So here this copyright concept, it came into existence. So here what is going on, here that copyright owner, that person is given some rights, and who is giving rights, that is the government. So government is basically giving rights, and these rights, they are legally enforced. So here it is a kind of negative right, it is not a positive right, it is a kind of negative rights, and thereby that it is prohibitory in nature, and it is a right to prevent others from copying or reproducing the work. Actually what will happen, suppose a person, that person has developed something, some basically intangible thing, a way of basically presenting some intangible thing. So here what is going on, basically here what is going on, that now that person should be incentivized, because that person has put his time, his efforts, his resources in developing that particular expression, that particular intellectual work. So basically for saving the rights, for basically protecting that person's right, what happened, this copyrights, they basically play an important role. And here what is going on, firstly these are negative rights, and secondly it is preventing others. There is also possibility that a person, if that person shows his work to other people, and then there are very high chances that other people, they may also think about copying that particular work. So to avoid such kind of instance, what happened, governments in all over world, they realize that the people who have basically developed something new, something unique, so such people, they should be incentivized through the intellectual property rights. So this copyright is basically a part of intellectual property rights, which also includes patents, trademarks, etc. So here what is the object of this copyright, that is to encourage authors, composers and the artists to create original work by rewarding them with the exclusive right for a specific period to reproduce the work for publishing and selling them to the public. So here we are, what we are doing, as we have discussed, that we are rewarding. To whom we are going to rewarding? The person who is holding such copyrights. But here what is going on, that these exclusive rights, they are basically given for a specific period. So a specific period is basically government has made that in that much particular time period, a person, a copyright holder is given power to basically sell, to basically reproduce the work for publishing, and through that, that person may basically earn some economic means or may get fame. So the moral basis of copyright law rests in the 8th commandment, thou shall not steal. And copyright, it is not a single right, it is a bundle of rights. So generally we think that copyright we are given just one right, but it is not true. Here we are not getting a single right, we are getting a bundle of rights, means so many rights we are basically given for the same work. And for example, in the case of literary work, copyright consists of reproduction in print media, the right of dramatic and cinematographic versions, the right of translation, adaptation, abridgment, and the right of public performance. So that person is not only given one right, what is going on depending upon the work, that what kind of work it is it a literary work or it is a cinematographic work. So on the basis of work, what is going on, certain rights are given, that like the right of translation, that in case that particular work, if it can be translated in other languages, so even in other languages that person is having will remain have copyright or right to basically earn some economic means or right to make money. Beside this, copyright, it consists not merely of the right of reproduction, it also consists of the right to works derived from the original work, rights like the right of public performance. Suppose that person, suppose a person has written a play, so what would happen in case if a public performance is basically done with that particular play, then what will happen here again, that right holder, that copyright holder is having right, and that right he can basically use for public performance. Beside this, the recording right, so he can make n number of copies if he thinks, if he or she thinks that they can sell that particular things, copies in the market, so they can basically reproduce as many number of basically copies. Beside this, broadcasting right, so suppose we have to broadcast, we have to telecast, so in such situations also that copyright holder is having rights. And such kind of rights like broadcasting rights, recording rights, rights of public performance, they all are basically comes under category of neighboring rights. So this is a reason why we are saying that copyright, it is not a single right, it is a bundle of rights. Now to secure copyright protection, the author must have bestowed upon the work sufficient judgment, skill and labor or capital, and it is immaterial whether the work is wise or foolish, accurate or inaccurate, or whether it has literary merit or not. So here what is going on, that here one important thing is that whatever work is basically done by an author, what is going on, whether it is foolish or wise, whether it is accurate or inaccurate, in all conditions that person is basically eligible for getting copyrights, and that person basically protect his rights by using the basically laws or the rules made by government. Next is the owner of a copyright, that person has no monopoly in the subject matter. Others are at liberty to produce the same result provided they do so independently, and though they are not first in the field, and their work is nonetheless original. Here initially we were when we were discussing about this topic, we talked about this monopoly, but here monopoly doesn't mean that copyright holder is having complete monopoly on the subject matter. On that subject matter, other authors, other people, they can also do work, they can also present their work. Here what is going on, only the procedure, only the way, that should be the independent. So if this copyright holder, if that person has reached on a certain conclusion, and other people, other authors, they have also reached on the conclusion, then still this copyright holder cannot say, cannot blame on other people that why you are reaching on that conclusion. Reason is that that the other authors, they have reached on the same conclusion independently. Nextly, there is no copyright in ideas. generally, as we are talking about that, it is basically a kind of right which is given on basically expression, but still this is one of the limitation that on ideas you cannot get copyrights. And copyrights, basically it subsides only in the material form to which the ideas are translated. Since there is no copyright in ideas or information, it is no infringement of copyright to adopt the ideas of another or to publish information derived from another, provided there is no copying of the language in which those ideas have or that information has been previously embodied. So, in case suppose there is another person who is also working on the same area, on the same field. So, one thing which is very important, that the language, it shouldn't be copied. If it is copied, then what would happen? That person will come under the case of infringement of that copyrights. So, another person can also reach on the same conclusion, can also write the similar kind of things, but that person basically need to work independently. Then copyrights, it subsides in original literary, dramatic, musical and artistic works, cinematographic films and sound recording. So, these are the areas in which a person what can do? A person basically apply for copyrights. So, firstly the literary work, then dramatic, musical, artistic work, cinematographic films and sound recording. So, all these are the areas in which a person generally basically works and can get copyrights. So, literary work, it includes computer programs, tables, compilation including computer database. Dramatic work includes any piece of recitation, choreographic work or entertainment in a dumb show, the scening arrangement or acting form of which is fixed in writing or otherwise, but does not include cinematographic film. So, this is an important thing here. Reason is that for every work what we are getting to see, the definition is getting changed. So, we firstly need to analyze that what kind of work we are doing and what kind of rights a person can attain, and in which situation if that person is using others' work, then it would come under the category of infringement. Then music work, it means a work consisting of music and includes any geographical notation of such work, but does not include any works or action intended to be sung, spoken or performed with the music. Next is an artistic work. It means a painting, a sculpture, a drawing, including diagram, map, charts or plan, an engraving or a photograph, whether or not any such work possesses artistic quality. A work of architecture means any building or a structure having an artistic character or design or any model for such building or a structure. So, not only in the artistic work we are getting to see that painting, sculptures or drawings, they are coming under the this category. For the architectural work as well, if suppose a person has designed a structure of a building, so that will also come under the category of copyright. The next is the cinematographic films. So, it means any work of usual recording on any medium produced through a process from which a moving image may produced by any means and includes a sound recording accompanying such visual recording, and cinematograph shall be construed as including any work produced by any process analogous to cinematography, including video films. So, here what is also going on, that in case if we have to talk about the cinematographic, so firstly there should be a moving image, and whether in any form, how whatever way you are basically trying to move it, that is basically not necessary to count, but it should always move. This is an important thing. Next is the sound recording. It means a recording of sounds from which such sounds may be reproduced regardless of the medium on which such recording is made or method by which the sounds are produced. Now, the word original does not mean that the work must be expression of original or incentive thought. It only means the work must not be copied from another. So, original work, generally we think that always new things should be developed, new things should be created. It is not necessary. Here the simple, or in a layman term, what is going on, it is very much expected from every person who is basically asking for such rights, that that person hasn't copied, that thing shouldn't be copied from another work. Suppose any other person has done the same thing and another person is also basically, and one person is basically copying the whole thing. So, it shouldn't be. Here originality simply means that that work shouldn't be copied from another work. And nextly, now there are some parameters to qualify for copyright in India. So, firstly, the work is first published in India. Secondly, where the work is first published outside India, the author at the date of publication must be a citizen of India. So, firstly, either it should be published in India, or that person whose work it is, that person must be Indian citizen. And if the publication was made after the author's death, the author must have at the time of death been a citizen of India. Nextly, in case of unpublished work, suppose there is a work which is unpublished, so at that time what will happen? So, on the date of making of the work, it is a citizen of India or domiciled in India. Now, we will discuss about various rights which a copyright holder gets. So, firstly, the economic rights, so monetary benefits related rights. So, in case of a literary, dramatic or musical work not being a computer program, the rights consist of to reproduce the work in any material form, including the storing of in any medium by electronic means. Secondly, to issue copies of the work to the public. Suppose a person wants to sell copies of that particular work, so that copyright holder is having right to make copies of it and then sell it into market. Nextly, to perform the work in public or communicate it to the public. So, it is again an important thing that if a copyright holder, if he feels that he has done something unique and he wants to demonstrate it in front of people, so that power is also given to a copyright holder. Nextly, to make any cinematographic, film or sound recording in respect of the work. So, some work, suppose a person has written a book, now later on a movie or short film we want to make. So, that copyright holder is having right to do all such things. Nextly, to make any translation of the work. Suppose that particular work, it has become very famous. Now, the author, now the copyright holder, he feels that now I should basically produce its copy in another languages as well. So, that right is also given. Then nextly, to make any adaptation of the work, certain changes, is we want to bring some small changes, so we can also do the same. Beside this, to do in relation to translation or adaptation of the work, any of the acts specified in relation to the work in subclause 1 to 6. So, in copyright laws, basically it is specifically defined that what kind of changes you can basically bring in that work, how you can basically make money, or how you can basically use your economic rights. Nextly, in the case of computer program, to do any of the facts specified in clause A, so all these things should be added one. Beside this, to sell or give on hire or offer for sale or hire any copy of the computer program, regardless of whether such copy has been sold or given on hire or earlier occasion. So, further clauses of basically what we want to do, we want to sell it or we want to basically give on hire. So depending upon all such things, another clause is also added. Next is in case of an artistic work. So to reproduce a work in any material form, including depiction in 2 dimensions or of a 3-dimension work, to communicate the work in public, to issue copies of the work to the public, to include the work in any cinematographic film, to adapt the work, to do about an adaptation of the work, any of the acts specified about the work in subclauses 1 to 4. Nextly, for cinematographic films, so here to make a copy of the film, including a photograph of any image forming part thereof. Secondly, to sell or give on hire or offer for sale or hire any copy of the film, regardless of whether such copy has been sold or given on hire on earlier occasion. Thirdly, to communicate the film to the public. Now in the case of a sound recording, so to make any other sound recording embodying it, to sell or give on hire or offer for sale or hire any copy of the sound recording, regardless of whether such copy has been sold or given on hire on earlier occasions. Thirdly, to communicate the sound recording to the public. So all these were the economic rights. Now we will discuss moral rights. So firstly, to decide whether to publish or not to publish the work. So that person is also having right that what he wants to get it published or not. Secondly, the right to claim authorship of a published or exhibited work. So here what is going on, that author may think, he may realize that that particular thing is very important. So that person may say to common man to that they can also basically utilize it, or at that time that person himself is not claiming for the authorship of that particular published work. Thirdly, the right to prevent alteration and other actions that may damage the author's honor or reputation. The right of integrity. This is an important thing that we basically should give a person right, so that that person's image that shouldn't basically be spoiled. Nextly, to restrain or claim damages. So in case if any damage take place with author, so at that time that author is given right to claim it. Now the term of copyright. So for how long a person is basically given such right. So in the case of any literary, dramatic, musical or an artistic work other than a photograph, lifetime of the author plus 60 years. Now in the case of photograph, cinefilms, sound recording and government work, 60 years from the beginning of the calendar year next following the year in which the work is first published. And in the case of broadcaster, performers, reproduction right shall subside until 25 years from the calendar year next following the year in which the broadcast or performance is made. Now we will talk about the ownership. So author and ownership of copyrights, which basically comes under section 2D. So the author in relation to various categories of the work is as follows. So for the literary or dramatic work, that person is known as author of the work. For the musical work, that copyright holder is known as composer. For artistic work, copyright holder is known as artist. For photograph, that person is known as photographer. For cinematograph film, that copyright holder will be known as film producer. For sound recording, that person will be known as the producer. So literary, dramatic, music or artistic work which is computer generated, the person who causes the work to be created. Now, the owner of copyright. Normally, the author of the work will be the first owner, subject to following exceptions. So, some exceptions are also present. It is not necessary that always the author or person who is claiming for copyright will always be given. Certain exceptions, they are also present. So, firstly, where a work is made by the author in the course of his employment by the proprietor of a newspaper, magazines, periodicals for publication therein, then such proprietor will be the first owner. So, here in case if that person is an employee and that person has got employment somewhere, so the proprietor or the owner of that particular company or that particular newspaper, magazine, publication house, that person, that company is having right or the first ownership. Nextly, where a photograph is taken or a painting or a portrait drawn or an engraving or cinefilm made for a consideration at the instance of any person, then such person shall be the first owner. So, in the case of photograph, painting, here what is going on? The person who has taken, who has made that painting, that person will be the owner. And when a work is made in the course of the author's employment under a contract of service or apprenticeship, the employer will be the first owner. So, here a person, if that person is working regularly or on contract, here again what we are getting to see, employer or the proprietor will be the first owner. Now, where any person has delivered any address or speech in public, that person will be first owner of the copyright. And in the case of government work, definitely the government is the first owner. Now, condition comes under infringement. So, copyright in a work is deemed to be infringed when any person without a license. So, there is a person except copyright holder and that person is not granted license. So, without a license granted by the owner of the copyright or registrar of copyrights or in contravention of the condition of a license so granted or of any condition imposed does anything, the exclusive right to do is conferred upon the owner of copyright or permit for profit any place to be used for communication unless he was not aware and had no reasonable ground for believing that such communication to the public would be infringement of the copyright. So, here what is going on? Other person is basically using the work of a copyright holder. So, in such situation that will come under infringement. Secondly, if there is a person, there is any person who is basically making for sale or hire or lets for hire or any way of trade, display or offers for sale or hire or distribute either for the purpose of trade or to such extent as to prejudicially affect the owner of the copyright or by way of trade exhibits in public or imports into India any infringing copy of the work. So, here what is going on? Here we can clearly see that there is a person who is basically trying to misuse copyrights of any other person for making some money. So, that person may try to sell it, may try to copy it, may try to import it from any other country. So, in all such conditions what will happen? This basically infringement of copyright will take place. So, that is all for today's topic.